Welcome, everybody. Welcome to today's episode of The Law of Self-Defense. Let's see, is my audio working correctly? And let's see. It looks like we are. Can you folks hear me okay? Sound check, 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 check. I've been out of the office for a week. I never know if someone's tampered with my computer while I was away. All right. Good, good, good. All right. So, yes, I'm back in the office. I'm back from my what turned out to be a 2-week motorcycle trip. Hadn't planned it to be quite that long, but it got stretched out a little bit. Had an awesome time, of course, riding the motorcycle, meeting up with friends in Southern California, friends in Las Vegas. Rode through Durango, Colorado, Bryce Canyon, Zion National Park, Pacific Reef, Glen Canyon. Just gorgeous, gorgeous terrain through southern Utah. And of course, Southern California was Southern California. What can I say about that? Except there are people I like who live there. So it was a great trip, home safe and sound. For those who may not know, this is, of course, the Law of Self-Defense show, and I am attorney Andrew Branker for Law of Self-Defense. Thank you. Thank you very much for all of that. And today we're doing a one of our live open access shows. So about half the shows we do each week are members only content. This is one of the shows we're streaming open access to, of course, our Law of Self-Defense members on their dashboard. And by the way, if you are a member, that's where you should be, because you get to pose all your questions and comments there for free, the ones you'd like me to address. And we're also streaming on YouTube, Rumble, and Twitter. If you are on YouTube or Rumble, I would appreciate it if you would hit the thumbs up button on those platforms. Hit the subscribe button. We're darn close to 50,000 subscribers, folks. 48.9 thousand subscribers. Would be great to get to 50. And if you could leave a comment on YouTube or Rumble, even if it's just your city and state, that helps trigger the algorithm into spreading our content more broadly. So that's always greatly appreciated. I mentioned that I encourage everyone to be a Law of Self-Defense member, because you get to ask your questions there for free. If you're watching this on YouTube or Rumble and you would like a question of yours answered, it needs to be a $5 minimum YouTube super chat or a $5 minimum Rumble rant. $5 a question, folks, on YouTube or Rumble. Or for 99 cents, you could become a Law of Self-Defense member. Try it out for 2 weeks for just 99 cents and get all your questions and comments answered for free in the member dashboard, where we're also live streaming this. And after the 2 weeks, if you decide it's not for you, you can cancel and you'll get a 200% refund. So it's a negative risk opportunity. And if you stay a member, and virtually everybody does, it's only 30 cents a day, folks. It's less than $10 a month to be a standard Law of Self-Defense member, which gets all your questions answered for free on any of these live shows, plus gets you access to the roughly 50% of our weekly content that is members only content. For example, we just did a initial analysis of the Banco Brown shooting in San Francisco. This is where the Walgreen armed security guard shot the homeless transgender person who was shoplifting at the store, killed him. And the San Francisco DA has decided not to charge that security officer. We have access to the video now, and frankly, it looks like a pretty sketchy shooting to me. We covered that just recently within the last couple of days as members-only content. Did our initial legal analysis take on that particular case. More to follow, but only our members got access to that Banco Brown legal analysis a couple of days ago. For 30 cents a day, folks, you get access too. And you can do that right now, immediately, at lawofselfdefense.com/trial. So today we are here to talk about an appellate decision that just came out of Washington State. And this was brought to my attention by a colleague lawyer who some of you may know. She is Andrea Burkhart. She is one of the law tubers in the community, works out of Washington State. She worked on this appeal for this appellant, the defendant at trial, the appellant on appeal, and she won a reversal for her client, which is an amazing accomplishment. Fewer than 1% of appeals result in meaningful relief for the client. Often that relief is simply, say, a reduction in sentence. It's very rarely a reversal of a conviction and a remand for retrial, or as this appellate court put it, a remand for further processing. So suggesting that maybe a retrial is not desirable here. But a huge win for Andrea. Congratulations, Andrea. Very, very difficult to win on appeal. And what interested me about this case is the basis for the appeal was essentially ineffective assistance of counsel on the grounds that the trial lawyer for the client here didn't understand self-defense law. And the trial court apparently didn't understand self-defense law. But we have a constitutional right to effective assistance of counsel at trial, and to the extent the trial counsel was ineffective at trial, that's the grounds here for this conviction being reversed. By the way, ineffective assistance of counsel claims are made all the time. Everyone who's convicted believes that they must have been convicted because their lawyer sucked. They're never successful. Never. Once in a million. And Andrea got this reversed based on ineffective assistance of counsel, as she should have. Counsel was ineffective. And so the core error here of trial counsel was that they did not raise the legal defense of self-defense to the crime of first-degree manslaughter, which is what this client was convicted of, because they misunderstood that self-defense as a legal defense didn't apply to first-degree manslaughter. They're wrong about that. But because they didn't raise the legal defense, there's a prospect the verdict of guilty would have been different had they properly raised the legal defense of self-defense to the manslaughter charge. And so that's the basis for the appellate court reversing this conviction, as they should have. The real take-home message for all of you folks is, can you trust, as a matter of faith, that your trial lawyer who's defending you in a self-defense case, where, by the way, this client was initially charged with murder. First-degree manslaughter was a lesser included charge that she got convicted of. She was initially charged with murder, life in prison, if convicted. And the only legal defense here was self-defense. And the trial lawyer screwed it up. So heaven forbid you have to use deadly force in self-defense, find yourself criminally charged, and you've retained trial counsel. Can you trust, as a matter of faith, that your trial counsel actually understands self-defense law, your only legal defense? The answer is no. You can't, as this case illustrates, because this client couldn't. You think she knew any better? You think she knew her trial counsel didn't really understand self-defense law? No, of course not. Most of you are completely unequipped to evaluate the quality, the actual subject matter expertise of a lawyer. You're just not. You don't know what to look for. You don't know the right questions to ask. You don't have a sense of what the answers should be. You just presume because the person has a certificate on their wall, they graduated from law school, they've been admitted to the bar. By the way, just renewed my bar license. 32nd year, folks. 32nd year, not being a real lawyer on the internet. Because they went to law school, got a JD, and passed the bar, you presume that they're competent in what they do. But that's often not the case, sadly. Lawyers, like any other profession, are on a bell curve. And some of them are on the far right of the bell curve, and they're world class. And most of them are in the middle, and they're okay. But some of them are on the left side of the bell curve. And they're a threat if you rely on them. But unfortunately, most of you are not equipped to make the evaluation of where on the bell curve those lawyers are. You can fix that, and I'll explain how to fix that in a bit. You can make yourself an informed consumer of legal services, at least in the self-defense context, which of course is my arena. So again, congratulations to Andrea, a very rare win on very rare grounds, ineffective assistance to counsel. Kudos to her. But the take-home message for us really is don't simply presume that your lawyer knows self-defense law if you're a defendant in a self-defense case. I've said this before, but I'll say it again. In my 3 years of law school, we spent maybe 5 minutes talking about self-defense law. First year criminal law. 5 minutes, maybe 10 minutes. That's it. So we lawyers are not really taught self-defense law in law school. And there aren't a lot of good resources for teaching self-defense law after law school. I can tell you, I've been accredited to teach continuing legal education, meaning instruction to other lawyers, to judges on self-defense law in 35 states. And invariably, those legal professionals tell me it's the best CLE they've ever had of any type, but particularly in the context of self-defense law, because they're simply not well educated on self-defense law as a legal justification. That's why we teach CLE, to educate the legal community. But of course, we can only reach so many lawyers. The best defense against you ending up with ineffective assistance of counsel as a self-defense client at trial is to arm yourself by arming your mind with self-defense law to the extent you can. You can't all be lawyers. And I would suggest to have me as part of your legal team to make sure these things don't happen. Because I can assure you that there is no trial counsel who's going to drop the ball on self-defense law if I'm part of your legal defense. It can't happen. All right, so let's pull up this case here. Now, this is a appellate court decision. It's 20 pages long. I think it is from time to time. Some of you, I don't know, I've not heard complaints really, but it wouldn't surprise me if some of you find these opinions to be kind of dry. But folks, this is the actual law. This is where the rubber meets the road, is in these appellate court decisions. And fortunately, because they are 20 pages long and they do involve explanations, we can see the reasoning of the courts. But keep in mind, laws basically come in two forms. Well, I mean, three forms if we include, the federal and state constitution. But in terms of what we think of normally as laws, they're statutes, right? And they're numbered and they're passed by the legislature and signed by the governor. But statutes don't have any effect in the real world by themselves. They're just words on a piece of paper. Statutes don't have any effect in the real world until they are interpreted and applied by courts, by appellate courts, to real clients in real cases. And of course, by trial courts too. But when trial courts make decisions, make rulings, they don't have precedential value. When trial courts make decisions, it's controlling only on the people involved in that trial. It's not until we get to the appellate courts that the appellate court decisions have precedential value, are controlling on the courts below them in the hierarchy. Think of it as a pyramid. You have the trial courts at the bottom. There's lots of those. Then you have a smaller number of mid-level appellate courts, typically called the Court of Appeals. There's a bunch of those, but fewer than the trial courts. And then at the very top, you have the state Supreme Court. And the authority runs downhill. So what the state Supreme Court says is controlling on the mid-level appellate courts and on the trial courts. What the mid-level appellate courts rule is controlling on, themselves and the trial courts below them. So authority runs downhill. And it's the mid-level appellate courts and the state Supreme Court, their decisions create precedential value. And it's their interpretation of statutory language and their application of it in these appellate court decisions that also creates law, called case law. And it's just as valid as statutory law. In fact, arguably, it's more valid in the sense that it's not unusual for the appellate courts to interpret and apply statutory language in a way that may seem contrary to a plain English reading of that statute. So the statute can well end up meaning not necessarily what the legislature intended the statute to mean, because the legislature is not applying the statute. the statute ends up meaning what the courts interpreting and applying that statute means. So if you've read, and I know this is very common for those of you who have your concealed carry permits, you probably went and took a concealed carry class sometime, and at some point the instructor got up there and did the legal portion of the class and read you a bunch of statutes, self-defense statutes in your state. And that's great. You do need to know those. But if you've only read the statutes and you haven't read the case law that interprets and applies those statutes, you don't really know what those statutes mean, because they don't necessarily mean what their plain English reading of them would suggest. So fair warning there. So I think it's useful from time to time for us to read through an actual appellate court decision. You can see how they're structured. You should be reading decisions yourself, and hopefully by doing it together here, you can learn how to distill the essential information from these cases, put them in context, and we can facilitate your ability to do this on your own. Learn the law on your own, empower you to do that. So this case is State of Washington versus Leslie Melgar Moreno. And it was handed down, filed yesterday. Doesn't get much fresher than that, folks. So as typical with the structures of these appellate decisions, we kind of get a quick overview of what happened at trial, what's happening on appeal. Usually they'll give you a spoiler right up front about what the appellate court's ultimate decision here is in the case. They'll do a review of the facts of the case. Normally these facts are interpreted in the light most favorable, most consistent with the conviction at trial. So when you're at trial, all the legal presumptions are in your favor. You're presumed innocent until you're proven guilty beyond a reasonable doubt. But once you're proven guilty beyond a reasonable doubt at trial, you're presumed guilty. And the facts are presumed to be the facts that are the version of the facts, the narrative that is consistent with that guilty verdict from the jury. Remember, at trial, there's two competing narratives, right? A narrative of guilt and a narrative of innocence. Well, once you're convicted, it's presumed that the narrative of guilt is the correct one, that the jury made the right call. In fact, the appellate courts are loath to question the fact-finding of the jury. That's the province of the jury. And remember, the appellate courts don't see witnesses. They don't hear testimony, typically. We do have a kind of an exception here in ineffective assistance to counsel cases. The appellate courts will sometimes hear testimony from the trial lawyer to try to understand why the trial lawyer made the decisions they made at trial. Was it a strategic decision, which is perfectly acceptable, not a violation of your constitutional right to effective assistance of counsel, or was it stupidity, error on the part of trial counsel, in which case it may be ineffective assistance of counsel. So we have a rare instance here, because this is fundamentally an ineffective assistance of counsel claim, that the appellate court may have heard some actual testimony from the trial lawyer. But generally speaking, the appellate courts don't hear testimony. They don't see witnesses. They can't evaluate their credibility, their demeanor, all of that. So the jury did all that at trial. So the appellate courts don't like to review facts, fact-finding from the trial. They will review, of course, legal errors that are made. That's their real purpose. And that's what they did here. So they'll do a review of the facts, normally viewed in the light most favorable, most consistent with the conviction. And then they'll get to, let's see, we're going to go through this in detail. Then they'll get to a legal analysis case, a portion of the decision where they'll determine whether or not legal error was made. And eventually we get to the end where they have their conclusion. And the conclusion here was that the conviction is reversed and the matter is remanded for further proceedings. I found that last sentence interesting. This may be normal for Washington State. I've never practiced in Washington State. Normally, the appellate courts would say the matter's remanded for retrial, as if it's automatic, really, that the reverse conviction, the appellant will be tried again a second time. This almost seems to be suggesting that the appellate court's hinting that maybe a retrial isn't necessary or appropriate. It's a little vague. Of course, whether or not there is a retrial is in fact not automatic. It's entirely at the discretion of the prosecutor, whether they want to bring the case again. Often they do. Sometimes the ruling that reversed the conviction clarifies the law, the proper law, in such a way that the prosecutor realizes, well, if that's the legal standard I have to meet, I can't get a conviction. and they decide not to have a second trial. But it's entirely at the discretion of the trial judge, unless a conviction was reversed with prejudice, which almost never happens. But in that case, the prosecutor is stripped of the option to do a retrial. And that's not what happened here. It was not reversed with prejudice. Usually reversal with prejudice would happen only if there was some bad conduct on the part of the prosecutor, hidden exculpatory evidence, for example. Even then, it's shockingly rare, but that's the kind of thing you would look for if a conviction were to be reversed with prejudice. All right, so State of Washington versus Moreno. Washington, or State v. Moreno, would be the abbreviation of this. And let's begin. So Leslie Moreno was charged with first-degree premeditated murder, but was convicted at trial of the lesser offense of first-degree manslaughter. So lesser included offenses, folks, are crimes that are very similar to the crime with which you're charged, except they have fewer elements. So imagine a first-degree murder had 4 elements, and the prosecution has to prove each and every element of that murder charge to get you convicted of murder. They have to prove each and every element beyond a reasonable doubt. And they can't do that. They can only prove 3 of the elements beyond a reasonable doubt, but not the 4th one. Well, then they can't convict you of murder because there's a required element of murder they didn't prove beyond a reasonable doubt, the 4th element of murder. But in theory, the lesser included charge of manslaughter may require not 4 elements, but only 3 elements. The 3 elements that the state can prove beyond a reasonable doubt. So in that case, you can have a situation where a defendant at trial is acquitted of murder because not all 4 elements were proven beyond a reasonable doubt, but convicted of manslaughter because the 3 elements of manslaughter, the lesser included charge of manslaughter, were proven beyond a reasonable doubt. Miss Moreno asserted a claim of self-defense based on a theory of either excusable or justifiable homicide. The jury was instructed on justifiable and excusable homicide as to first-degree murder and 2 other lesser offenses, but Ms. Moreno's attorney failed to request similar instructions as to first-degree manslaughter. So I have to say the appellate court here doesn't do a great job in providing clarity on all these different legal doctrines and concepts and crimes that we're talking about here. They're a little wishy-washy, which can cause confusion, probably because the appellate court itself does not have an extremely clear understanding of these doctrines themselves. That's normally the case. Remember, this is being reversed because the trial lawyer, and I would suggest the trial court, didn't properly understand self-defense law with the kind of perfect clarity you would want. The same is often true of the appellate court judges. They got to the right decision here, but they did it in kind of a wishy-washy way, in my opinion. Now, they mentioned both excusable and justifiable homicide. These are 2 different things. They can both result in an acquittal, but the path of getting to an acquittal is quite different in the 2 different justifications, excusable homicide and justifiable homicide. So justifiable homicide can be thought of as of course, a homicide is simply one person killed another person, but not all homicides are crimes. Not all homicides are unlawful. When a crime is unlawful, it would typically be a murder or a manslaughter, some flavor of manslaughter, either reckless manslaughter or heat of passion manslaughter. So either involuntary, unintentional manslaughter or intentional but hot-blooded manslaughter under adequate provocation manslaughter. And I'll talk more about those in a moment. So those are the criminal homicides, but some homicides are not criminal. Some killings of another person are not criminal. And those can be divided into 2 different buckets: justifiable homicides and excusable homicides. And conceptually, you can think of justifiable homicides as lawful homicides, so not a crime. The defendant would be acquitted. Lawful homicides in which the outcome is a social good. And this would be typical of self-defense, defense of others, are justifiable homicides. So a woman is attacked by a rapist. She pulls out her pistol and kills the rapist to prevent herself from being raped. Now, of course, in an abstract sense, any loss of life is unfortunate. But if we had to choose between the woman getting raped on the one hand or the rapist getting shot by the woman on the other hand, the social plus the social benefit, the social good is not the woman getting raped. It's the rapist getting shot. So that outcome is a social good. Same if there was an active shooter in a mall shooting people and somebody acted in defense of others and shot the active shooter. It's a social good, right? Better that the active shooter was shot than then the active shooter continued to shoot other people. Excusable homicide is a bit different. That's where we as a society decide that the killing, the homicide, should not be criminal, even though it was not a social good. It was a bad outcome that we would not want. And a classic example of an excusable homicide would be, for example, in the insanity defense, where you have someone waiting at a bus, and they're a pediatric oncologist. They save children from cancer. They provide huge value to society. Society's arguably invested a fortune in this person's education and training so they can do this. And then a lunatic walks up and shoots that person dead for no reason, because they're insane. Well, we may characterize that as an excusable killing, not because it's a good outcome. Nobody wishes the pediatric oncologist was dead, but because we decide that the insanity of the killer stripped them of the ability to form the criminal intent needed for the crime, for the killing to be a crime. So that's the difference. Justifiable homicide, social good. Excusable homicide, generally not a social good, but still deemed not criminal because of the lack of the required criminal mens rea, mental state on the part of the killer. So that's the difference between excusable or justifiable homicide. The jury was instructed on justifiable and excusable homicide as legal defenses to first-degree murder, but Ms. Moreno's attorney failed to request similar jury instructions as to first-degree manslaughter, which means the jury, when they were considering the murder charge, stapled to the murder charge was, but this is not a crime if it was either a justifiable homicide or an excusable homicide. But when they looked at the manslaughter charge, the lesser included, there was no legal defense stapled to that. Sound like a pretty big error? Sounds like it. Sounds like ineffective assistance of counsel to me. Now, counsel had a reason they didn't request the instruction, but their reason is a bad reason. Their reason is based on their misunderstanding of self-defense law. Let's see. 170 watching on YouTube. Only 170. Wow. But only 76 likes, folks. Come on, hit that like, thumbs up button, and the same on Rumble, please. Hit the Rumble. Hit the Rumble thumbs up. That would be greatly appreciated. So Ms. Moreno's attorney failed to request the justification instructions for first-degree manslaughter, and that trial attorney repeatedly admitted on the record. So this may have been the appellate court calling the lawyer in, saying, hey, tell us what your rationale was behind this, because we need to determine whether or not you made a strategic decision, which is perfectly fine. Lawyers have to make strategic decisions about what legal arguments they want to make all the time, or whether you just screwed up and made a mistake. So Moreno's trial attorney repeatedly admitted on the record that they did not make this request for the jury instructions on justifiable or excusable homicide with respect to manslaughter, based on their belief that the defenses of excusable and justifiable homicide did not apply to first-degree manslaughter. And I understand why they felt that way. They're wrong, but I understand why they felt that way. We'll talk about that. On appeal, and this is Andrea Burkhart arguing on appeal on behalf of Ms. Moreno. Ms. Moreno argues her trial attorney provided constitutionally ineffective representation when the attorney failed to seek self-defense instructions applicable to first-degree manslaughter. We agree. That's the appellate court. Trial counsel failed to recognize the defenses of excusable and justifiable homicide can apply to all forms of illegal homicide. Now, I will caution that the way self-defense works as a justification for reckless manslaughter is different than its normal application to an intentional killing. And this, I think, is where the trial attorney screwed up. They understood how self-defense applied in the context of an intentional killing, but failed to understand how it could apply in a subtly different way also to reckless manslaughter. That's the trial attorney's thinking error here, which would not have happened if I were on that defense team, folks. As a result, the court's jury instructions, by the way, the trial court should also have caught this. The trial judge can give instructions on their own initiative, sua sponte. They don't have to wait for the request of the defense attorney. Normally, during the course of the trial itself, the judge is supposed to be just a referee and not to interject arguments on behalf of either party. Sometimes they do anyway, but they're not supposed to. So if the defense attorney is not making an argument, the trial attorney is not supposed to make that argument on behalf of the defense attorney. Hey, defense counsel, are you sure you don't want to argue this? They're not supposed to do that. But when it comes to the jury instructions, it's different. The judge is supposed to instruct the jury on every instruction that has a basis in the evidence presented at trial. So the trial judge also should have provided the self-defense instruction with respect to first-degree manslaughter and didn't. The trial judge didn't. So I would argue the trial judge was also ineffective. As a result, the court's jury instructions improperly suggested Ms. Moreno's defenses did not apply to the offense of first-degree manslaughter, of which she was ultimately convicted. Because counsel's error sufficiently undermines our confidence in the outcome, we must reverse Ms. Moreno's conviction. Again, kudos to Andrea. Now, I will note, by the way, look at this date here. On December 28th, 2018, Moreno called 911 and reported she was driving her boyfriend, Marcus Alessio, to the hospital because he had been stabbed. Of course, she stabbed him, obviously. Now, note the date, 2018. This decision, reversing her conviction, was handed down yesterday, 2023. So it's not quite 5 years, closer to 4 years, 4 years, almost 4.5 years from the date of the event, the stabbing, to her conviction being reversed. That entire time, she's either been at trial or, having been convicted, being held in prison, awaiting appeal. So I always say appeals are for losers. And I say that for two reasons. One is you're only appealing if you lost a trial. If you win a trial, you were acquitted, and that's it. You're done. You can't be subject to further criminal prosecution because of double jeopardy under the Constitution. You won. You were acquitted. If you're appealing, it's because you were convicted, and you're appealing the conviction. So appeals are for losers because you lost. You lost a trial, like Ms. Moreno lost a trial. Also, for the reason I stated earlier, that when you're on appeal, all the presumptions are against you. It's not like a retrial. It's not a second bite at the apple. Whereas a trial, all the presumptions are in your favor. Now all the presumptions are against you on appeal. So it's a much more uphill battle than the trial was itself. So again, appeals are for losers. And by the way, even when you get your conviction reversed, again, she spent 4.5 years going through this process. She doesn't get those 4.5 years back, folks. The appellate court doesn't have a time machine to give her that time back. So no matter what, even if she were not retried and she just went about her life from this point forward, she still lost that time. So Moreno called 911. The boyfriend had been stabbed. Miss Moreno stated she could not remember what happened, but she and he had been fighting and struggling for control of a knife. She said that he was neither conscious nor alert and that her 4-year-old daughter was in the backseat of the vehicle. Dispatch convinced Moreno to pull over and wait for help. Law enforcement and paramedics met Miss Moreno at a way station just outside Walla Walla and discovered the boyfriend inside her Toyota Highlander. He had succumbed to a single stab wound to the heart. By the way, folks, I've worked a lot of stab cases, a lot of cases where women stabbed men, and you'd be shocked at how even a relatively short-bladed knife can reach the heart. If it's punched into the chest with even the force that a typical woman can bring to bear, it's not unusual for the tip of that blade to nick the heart, and then it's all over. Happens all the time. The boyfriend had succumbed to a single stab wound to the heart. A kitchen knife was found on the floor of the vehicle. She accompanied law enforcement to the sheriff's office where she agreed to an interview. No counsel present for the interview, of course. Don't do that, folks. When we do our full day law of self-defense advanced course, we spend almost an hour talking about interaction with the police and the aftermath of a use of force event. And while there may be a few things you might want to say to officers on the scene, responding officers, you don't want to talk to interrogators. Don't talk to investigators, detectives. There's no upside to you talking to detectives without legal counsel present, and probably not then either. So don't be doing this. Don't be talking to lawyers, to investigators for sure. Maybe don't even talk to the officers on the scene, other than asserting your rights, your right to silence, your right to counsel unequivocally. But if once the investigators come along, once you've been sworn, once you've been Mirandized, you got to shut up, except for asserting your right to silence, asserting your right to counsel unambiguously. Say it just like I just said it. But in her interview, Miss Moreno explained that the boyfriend had physically attacked her while the pair were inside her home and that he had threatened her with a knife. She claimed he had walked outside with the knife to her car. She stated she followed him. A struggle for the knife ensued, and the next thing she knew, he was covered in blood. She further stated that he had a history of suicidal ideation, and she wanted to prevent him from hurting himself, which would explain why she followed him out to the car, right? Which is an important fact, because that could be, she's explaining it as, hey, I went out there to help save him from himself, but how would a prosecutor characterize it? The prosecutor could characterize it as her going to the fight, right? She was following him. And if you go to the fight rather than the fight coming to you, it never really looks like self-defense to anybody. And by the way, I do feel obliged to raise a cautionary note here, and that is that domestic violence is a real thing. It tends to be more mutual than most people recognize. It's not solely a case of the male in the relationship abusing the female. Females, when there's physical domestic abuse, it's often reciprocated by both parties. They're both kind of broken. That's why they're in that relationship. But of course, nobody should be abusing anybody domestically. It's a terrible thing when that happens. It's bad. It's bad. It's bad. I will note that it's very common when a woman kills a man she's in a relationship with, for the lawyer to argue that part of the motivation behind the killing that might justify it or mitigate it is a history of domestic abuse by the male against the woman. And often, when those arguments are being made, there's an utter lack of evidence of prior abuse. So for all we know, it's a complete fabrication by the woman, by counsel, in the moment to try to mitigate the severity of the killing. Of course, real domestic abuse does happen. Sometimes there is a long history, documented history of the abuse. But just because it's being claimed by trial counsel doesn't mean it actually happened, right? Always look to the actual evidence. Let's see. Multiple law enforcement officers noticed Moreno had fresh facial injuries, including bruising and redness, a swollen lip encrusted with blood, and a developing black eye. Law enforcement deemed her cooperative and released her. So she'd been in a fight, right? Presumably, the bruises, the injuries were at the hands of the boyfriend. Does that automatically mean the killing of the boyfriend was lawful? No, not necessarily. It's certainly relevant information. And if she killed him while she was in the process of defending herself from an imminent ongoing attack from him, that would certainly be consistent with self-defense. But it's also possible to imagine people do this all the time. One person beats up another, the fight's over, and then the person who was beat up goes and gets a weapon and kills the person who just beat them up. That's vengeance. That's not lawful self-defense. So the bruising and so forth is absolutely relevant to a self-defense argument. It's not controlling. It's not definitive on the question. Although, of course, the trial counsel will try to make it appear to be so. Naturally, certainly that's what I would do. Meanwhile, officers went to her home for further investigation. The interior of the home showed signs of a physical altercation. Contact with a neighbor who lived across the street, resulted in acquisition of security, surveillance video. There's video everywhere, folks. Always assume you're being recorded. The video captured the altercation between her and the boyfriend in the driveway at the time of the shooting. Quoting now, as summarized by one of the detectives at trial, the video revealed that the boyfriend can be seen coming out of the garage. He walks out to the vehicle, and then she is walking out shortly thereafter. Within a few seconds, he gets in the vehicle, and she comes out with a knife in her hand, or what appears to be the knife. And she's carrying it in her right hand, and you can see her as he's standing at the door. They're yelling back and forth. They're talking about problems with money, and she doesn't want him to go waste gas, and that it's her gas and her money, and he's saying he doesn't care. And, he's yelling, have you done anything for me? Have you filled out any applications for me? And she's saying, my effing gas and my effing money. And while they're having this exchange, she lifts the knife above her head with the blade pointed forward, and he kind of steps or leans back a little bit briefly, and there was a little bit more arguing, and then he sits in the vehicle, and they argue back and forth a little bit. That's the end of the quote there. Now the appellate court continues. At the point described above, where the boyfriend stepped or leaned back, she lowered the knife. He got into the driver's seat of the car with the door open. She leaned her head, arms, and upper torso into the vehicle multiple times, entering the driver's side where he sat. The first time she leaned back out of the vehicle, the knife was no longer in her right hand, but her left hand was not visible. She was the last one seen on the video holding the knife, though the footage does not show exactly what happened each time she leaned into the vehicle. At some point, the vehicle's horn honked and reverse lights came on, and the vehicle backed up slightly, indicating he had started it, the boyfriend. Three long muffled moans can be heard from him while she's leaning inside the vehicle. Within seconds, he got out of the vehicle, stood upright, and crossed. Within seconds, she got out of the vehicle, stood upright, and crossed her arms, paced for a moment, and then returned her upper body briefly into the vehicle's interior. At that point, there was nothing in her hands. She can then be seen running inside the house, and about 6 seconds later, she emerged with her daughter, who she secured in the backseat of the vehicle. She then drove away, seated on his lap. So I guess he was probably unconscious. She couldn't move him. He might have been too big. She's actually sitting on his lap driving the car. Ooh. The video contradicted her statement that the boyfriend was the one who walked out of the house with the knife. Based on information gleaned from the video, she was arrested. She was eventually charged with first-degree murder, and her case proceeded to a jury trial in February 2021. So from 2018, December 2018 to February 2021, so about a little over 2 years. I don't know if she was out on bail or not. She was charged with murder, so quite possibly not. And so this is very common, right? The detectives interview a suspect. The suspect's story sounds good. They release her, and then they go collect new evidence that's inconsistent with the narrative she told them. You think that makes law enforcement suspicious when the facts they collect elsewhere are inconsistent with your narrative? Yeah. And that's true even if your narrative is true to the best of your ability. And that's a danger, even for lawful cases of self-defense, folks, because I can tell you that in many of these cases, even in artificially induced stress, like self-defense shooting simulators, which I ran for many years as part of my classes, it projects an image of a potential threat, and the student has a fake gun. They have to solve the problem. Then they have to explain afterwards what they saw, what they did, why they did it, what their legal rationale was for whatever use of force decision they made. Those students in that completely artificial environment in which there's no actual danger of personal injury, they can't remember what they saw, they can't remember what they did, and they can't explain what their legal rationale was. So the way our brains capture and store and recall information under stress is completely different than our normal experience. So you could be recounting to detectives what you think is an accurate rendition of what happened. You believe it to be true. You're not lying, but you're wrong. You're making factual mistakes about potentially very relevant matters. And the mistakes themselves don't make your use of force necessarily unlawful, but if they're inconsistent with other people's statements or inconsistent with video secured, it's going to look to the officers like you're a liar. Remember, they don't know what really happened. They weren't there when you were attacked. All they can do is look at the evidence. And if other evidence is inconsistent with your narrative, it looks to them like maybe you're lying about what happened. Maybe that's consciousness of guilt. So she proceeded to a jury trial in February 2021 on the charge of first-degree murder. At trial, she took the stand and testified in her own defense. And by the way, folks, I think in most self-defense trials, good guy cases of self-defense, you really have to take the stand. It's difficult to see how you could get away with it. Juries, even if you have a genuine, unbiased, impartial jury, they understand in general the concept of self-defense. You're not supposed to just let yourself get killed if you're attacked by someone with deadly force. But there's a dead person, and they generally want to know why is that person dead? Why did this have to happen? And if it's only two people present, you and the person who died, they have to hear it from you. Now, there are rare exceptions to this. Rare exceptions would be like the George Zimmerman case, for example. George Zimmerman never took the witness stand in his own defense. But in his case, he had given, again, a lengthy interview to investigators without a lawyer present, generally not a good idea. Plus, he had done walkthroughs with the police at the scene later, days later, explaining what happened, and that was all videotaped, and that videotape was shown to the jury by the state. So in essence, George Zimmerman was effectively allowed to testify without having to actually take the witness stand and be subject to impeachment and cross-examination. But remember, Kyle Rittenhouse had to take the witness stand, right? And he was subject to for more than 3 hours, famously crying on the witness stand, being cross-examined by prosecutor Binger. Because I think at the end of the day, the jury is thinking, listen, there may be a good reason why you killed this person, but we need to hear it from you in the absence of other compelling evidence. So Ms. Moreno took the stand, testified in her own defense. She described her relationship with the boyfriend and explained he suffered from drug addiction and suicidal ideation. She also claimed their relationship repeatedly cycled through periods of physical and verbal abuse, manipulation, and reconciliation. All of this is very common to domestic abuse relationships. She testified that on December 28th, 2018, she got home around midday from a doctor's appointment. She could hear the boyfriend in the bedroom. Because she was exhausted, she put her daughter down for a nap and fell asleep on the couch herself. She testified she woke up to the boyfriend screaming at her that he needed money for drugs. He was also throwing things at her. He tore down a rod in the coat closet, and she began arguing with him. She alleged that the boyfriend shoved her onto the couch and then went into the kitchen. At this point, she noticed he had a knife. Now remember, this is just her. He's dead, right? So he can't testify about what happened. It's only her. Is there any corroborating evidence of any of this? Maybe. The appellate court doesn't go into those kinds of factual details. Did the police get to the scene and the rod had been ripped out of the closet? That doesn't necessarily mean it went as she said, but it would be corroborating evidence. She testified that everything happened so fast, but so slow that her recollection doesn't add up. And she could not 100% certain distinguish between her own memory and what she had read in reports. Again, does that mean she's lying? Maybe, but maybe not. Our recollections of these high stress events are very, very imperfect. And that would be normal, even if she's entirely telling the truth as she believes it to be. She explained, I remember holding the knife, but I just don't remember walking out of the house with it. She testified that he screamed at her that he was going to take the vehicle, and she begged him not to because she did not have gas money. She described what happened next as chaotic, and it all happened really quickly. She said everything was just kind of happening, and I remember I was holding the knife, then he was holding the knife. She stated that at some point she let go of the knife, and then they were fighting over it back and forth while he sat in the vehicle. She testified repeatedly that she never intended to harm him with the knife. Okay, could that be an issue for self-defense? Yes, because generally speaking, and we do get a subtle variation of this when we talk about applying the legal justification of self-defense to reckless manslaughter. We're going to talk about that in a moment. But generally speaking, self-defense is a justification for an intentional act, not an accident. So you perceived a threat, you intentionally use force against that threat, and you're attempting to justify that use of force as self-defense. It's a classic legal defense of confession and avoidance. You're confessing not to a crime, but you're confessing to the underlying conduct. You're and then seeking to avoid liability on the basis of the legal defense of self-defense. You're not saying it wasn't me. You're not saying I didn't shoot that person. I didn't stab that person. You're saying the opposite of that. You're saying it was me. I shot and stabbed that person intentionally. but it was in the legal defense of self-defense. So this, I believe, is where the trial lawyer went awry, because they understood that self-defense applies to an intentional act, but they did not understand the more subtle application of self-defense to an unintentional act. We'll get to that in just a moment. He sat in the vehicle. Let's see where they were fighting back and forth over the knife while he sat in the vehicle. She testified repeatedly that she never intended to harm him with the knife. She explained, "I was afraid that he was going to hurt me if I was going to let go of it. I was scared that he would hurt himself if he took it with him. I was just in fear." At some point, she stated she saw just blood everywhere. And folks, when I mentioned earlier, I've worked a number of cases where women stabbed the guy in the chest with a knife and hit the heart or hit one of the aorta or large blood vessel, pulmonary artery. When that happens, the crime scene photos look like someone took a fire hose of blood to the scene. This was in a car. I would expect much of the car to be soaked in blood. When it's in like a bedroom or a stairwell, it looks like a hose of blood was sprayed everywhere. It's unbelievable how much pressure the blood sprays out with, how far it can travel. So there was blood everywhere. Then she related her experience of running inside to get her daughter, climbing into the vehicle and driving off. She reiterated her memory of the incident was fuzzy and explained that when she agreed to go to the sheriff's office, she remained in shock. So this is a way to mitigate anything incriminating she may have said during the interview with investigators at the station. And she probably was in shock. The trial court, which is why you shouldn't be talking to investigators without a lawyer present. Your lawyer's not in shock. You're probably in shock. The trial court instructed the jury on first-degree murder, that's the primary charge against her, along with the lesser included offenses of second-degree murder, first-degree manslaughter, and second-degree manslaughter. The court instructed the jury, it is a defense to a charge of murder that the homicide was excusable, and it is a defense to a charge of murder that the homicide was justifiable. So I mentioned earlier that one example of an excusable homicide would be like an insane person killing somebody. And we say that's not justifiable in the sense that the killing was a bad social outcome, not a social good, but we might nevertheless characterize it as non-criminal because of the insanity of the defendant. Another way you can get to an excusable killing is if you're doing something, a lawful act in a lawful way, meaning a non-reckless way, and somebody unpredictably dies as a result. And an example of this might be you go to visit your elderly aunt in her apartment, and she says, "Oh, it's lovely to see you again, nephew. By the way, as long as you're here, strong, muscular young man that you are, could you move my dresser from that side of the room to the other side of the room?" And you go, "Sure, of course, Auntie, I'd love to." And you move the dresser across the room. Unbeknownst to you, the floorboards on that part of the apartment are rotted out by termites. And when you put the dresser down over there, it falls through the floor and kills someone in the apartment below. Were you acting in a lawful way? Doing a lawful act in a lawful way, a non-reckless way? Sure. Was the death at all foreseeable by you or anybody in your circumstances? No. Is it a social good that the person below you got killed? No. Did you do it intentionally? Kill them. Use force against them. Were you trying to kill them by dropping a dresser on their head? No. So it's not a case of self-defense. It's not a justifiable homicide, but it could be an excusable homicide. Probably would be. Let's see. The instruction on the second-degree manslaughter, and second-degree manslaughter here, folks, is reckless manslaughter. So there's two flavors of manslaughter. One is heat of passion manslaughter. And this is the classic example here is where somebody comes home and they find their spouse in bed with a lover and they whip out a gun and shoot both of those people dead. That's not self-defense, right? But is it murder? Well, what the law says is the law wants to differentiate between a cold-blooded, premeditated murder and a hot-blooded, heat of passion, under adequate provocation murder, because the mental state is different. Premeditated murder, you formed the intent. Even if it only took an instant, you formed the intent to kill that person unlawfully. But if you're in the heat of passion, if you've been subject to what the law calls adequate provocation, your mind's in a different place, right? It's not a cold-blooded killing, it's a hot-blooded killing. And the law says, well, you've lost the ability to form the specific intent required of murder. We're going to mitigate the crime. It's still a crime, but we're going to mitigate the crime from murder to heat of passion manslaughter, essentially voluntary manslaughter. So you intended to use force against that person, but we're going to distinguish it from murder because of the heat of passion of the circumstances. That also comes up a lot in where people kill each other immediately following a fight. The heat of passion there is the fight they were having moments before. So that's voluntary manslaughter, heat of passion manslaughter. The other form of manslaughter is involuntary manslaughter, reckless manslaughter, unintentional manslaughter, where you didn't intend to kill, but you were acting in a reckless manner. And reckless is a specific mental state, mens rea, recognized by the law. Recklessness is when you knowingly are creating an unjustified risk of death to another, and then they die as a result. The classic example would be you kill someone while you're drunk driving. You didn't intend to kill anybody. You were just trying to get home from the bar, right? And particularly, you didn't intend to kill that person. You probably never saw them. They were in the pedestrian crosswalk, and because you were drunk, you didn't see them. You ran them over and killed them. Not an intentional killing. Not a heat of passion killing, but a reckless killing, because we all know if you get behind the wheel while you're drunk, you're creating an unjustified risk of death to others. We know that. You got drunk on purpose, or at least you consumed the alcohol intentionally. It was not an involuntary intoxication, for example. And you're acting in a reckless manner. You kill someone, it's a reckless homicide. It's an involuntary homicide, unintentional homicide. You didn't mean to use force against that person. It was recklessness. That's what the first-degree manslaughter charge is here, reckless killing. The theory would be she didn't mean to stab him with the knife. He got stabbed unintentionally while they were fighting over control of the weapon. Her intent was to seize control of the knife, not to stab him with it. Now, because it was not intentional, you might think that because self-defense nominally only implies to an intentional use of force, I meant to stab that person, but I did it in self-defense, that it would not have application to reckless manslaughter, unintentional manslaughter. That is what the trial lawyer thought in this case. And they were right in the sense of the traditional application of self-defense, but they were wrong because they didn't fully understand the total scope of self-defense. So the court instructed the jury that self-defense was a defense to murder, but they did not instruct the jury that self-defense was a defense to first-degree manslaughter. The instructions on first-degree manslaughter did not include any such self-defense language. The court's instructions explained the offense of first-degree manslaughter required the state to prove that she engaged in reckless conduct and that the boyfriend died as a result of that reckless act. In closing argument, the prosecutor reviewed the elements of first or second-degree murder and then addressed the offense of first-degree manslaughter, reckless manslaughter. The prosecutor explained, quote, "The standard for manslaughter in the first degree is recklessness," close quote. The prosecutor noted that the boyfriend was irate at the time of the incident. According to the prosecutor, it was reckless for Miss Moreno to follow after him and to chase him. It's reckless to chase him with a knife, and it's reckless to go in and try to stab him with a knife. These are terrible misstatements of the law by this prosecutor. Terrible. This would be like arguing that the person in the car who drove over the pedestrian, that their recklessness was not that they were drunk. They were not drunk. They were sober. Their recklessness was they failed to check their tire pressure before getting into the car. Well, that has nothing to do with why their car hit the person. I mean, should we check our tire pressure from time to time to make sure we're getting good mileage and won't have a blowout? Sure. But what has to be reckless is the conduct that actually proximately results in the death. It was not her following him out of the house with the knife that killed him. So even if that was reckless, and there's counter arguments to that. Maybe she had the knife in her hand because she wanted to be prepared to defend herself. against a violent boyfriend. But that's not what proximately resulted in his death. What needed to be the reckless act was the fight over the knife. But that's not what the prosecutor's arguing here. It's reckless to chase him with a knife. That's nonsense. Reckless to follow him, to chase him, nonsense. It's reckless to go in and try to stab him with a knife. Well, that's not recklessness either. Because if you're trying to stab him with a knife, that's just an intentional act. That's not recklessness. So what the prosecutor's doing here is either he doesn't know how, or he doesn't have the facts, doesn't believe he has the facts to argue recklessness appropriately. Or he does know how, but he doesn't have anything to work with. And so he's just trying to characterize a bunch of really unrelated things as reckless so that the jury, when they read the jury instructions, will check off recklessness as existing, as having been proven beyond a reasonable doubt. That's contemptible by the prosecution. In the defense's closing argument, this was the counsel found to be ineffective at trial by this appellate court. Counsel argued that Ms. Moreno acted in fear of the boyfriend in the moments before he was stabbed. They argued the evidence showed she did not intend to kill him. Defense counsel addressed the lesser included offense of second-degree manslaughter, which is different than what she was convicted of, and argued her conduct was not negligent as contemplated by the court's instructions. Defense counsel never addressed the offense of first-degree manslaughter or whether her conduct was reckless. So here again, we have the lawyers conflating very distinct legal concepts. So as I just explained, recklessness is when you knowingly create an unjustified risk of death and death results. Negligence is not that. Negligence is when you unknowingly create a risk and harm results. You didn't actually know you were creating the risk, but you should have known. A reasonable person would have known, but you didn't actually know. Well, if your mental state is negligence, that's only good for civil liability. Negligence is not sufficient for criminal liability. It's not criminal liability until you actually knew you were creating the unjustified risk, and then it's reckless. Recklessness is the mental state required for criminal liability, not negligence. Now, unfortunately, the law often creates confusion on this distinction because instead of using the terms negligence and reckless, they'll do something like say negligence and criminal negligence. Well, if they're using the phrase criminal negligence, that just means reckless. That's all that means. But people see negligence in both places and think it means the same thing. It doesn't. So when they say here, they argued that her conduct was not negligent, that shouldn't even be an argument you're making in criminal court. The argument is that it was not reckless, regardless of what charge you're talking about. After the defense closing argument, the prosecutor asked to address the court outside the jury's presence. Once the jury was gone, the prosecutor objected to the excusable or justifiable language in the court's instruction on second-degree manslaughter. The prosecutor argued it was improperly inconsistent to so instruct the jury on second-degree manslaughter, but not on first-degree manslaughter. The prosecutor summarized their opinion that those two different crimes aren't treated differently under the law. So it's a little unclear what's happening here. It sounds like the prosecution, so self-defense was instructed as a defense to murder, the primary charge. Then we have first-degree manslaughter and second-degree manslaughter. Ultimately, this defendant would be convicted of first-degree manslaughter. And first-degree manslaughter did not get a self-defense instruction stapled to it. Second-degree manslaughter did. And it seems that what the prosecutor is arguing here is, hey, Your Honor, if you didn't attach self-defense to first-degree manslaughter, you should also not have attached it to second-degree manslaughter. So we want self-defense gone for both. That's bad law. The correct law is that self-defense should be attached to both. The error is not that self-defense was stapled to second-degree manslaughter. The error is that it was not also stapled to first-degree manslaughter. So the prosecution has it exactly backwards here. Now, they are right that the two, first degree and second degree, shouldn't be treated differently for purposes of self-defense law. But they should, the answer is they should both be getting the self-defense legal defense, not that neither of them should be getting it. And here's where defense counsel makes a mistake. Defense counsel doesn't make the proper argument. They are treated the same for self-defense law purposes. They should both get the self-defense instruction. Instead, defense counsel says, no, they are treated differently. First-degree manslaughter, second-degree manslaughter should be treated differently in terms of self-defense. That's wrong. But to continue with the appellate court decision here, defense counsel asserted their belief that the defense of excusable and justifiable homicides were available to second-degree manslaughter, so it should get the self-defense instruction, but not to first-degree manslaughter. What? The court observed that regardless of the prosecutor's objection, the jury had already been instructed. So too late. Ms. Moreno's counsel reiterated their belief that self-defense was not legally available to first-degree manslaughter. You'll notice that I did not argue under manslaughter first the same issues because it's not available under manslaughter first. So this is a bizarre argument to me. Even if the defense was right, that self-defense should not apply to first-degree manslaughter. Why make this argument? Even if you believe it to be true, why not give your client the benefit of every possible defense? Argue the other side. Why are you arguing that your client should not be given the legal defense of self-defense? Doesn't make any sense to me. The jury acquitted Ms. Moreno of first-degree murder and the lesser included offense of second-degree murder, but returned a guilty verdict as to first-degree manslaughter, reckless, unintentional manslaughter. During her sentencing hearing, defense counsel twice reiterated their belief that self-defense was not available as to the crime of first-degree manslaughter, but was available to murder and second-degree manslaughter. Defense counsel explained, quote, the jury found that this was not an intentional act on Ms. Moreno's part. They found that she was reckless by taking the knife out. Your Honor, we did not have available to us the same self-defense argument as we would have if the jury found it an intentional act. For a reckless act, Your Honor, there is not the defense of self-defense. We saw that with the jury instructions. That is something that goes along with an intentional act as set out in the jury instructions, or if the jury would have found it was a negligent act. Just not clear thinking here. Close quote. Ms. Moreno received a sentence of 126 months imprisonment, so just over 10 years. She now appeals. All right. So before we get into the court's legal analysis, which, by the way, I have not read, so I'm reading this cold along with all of you, here's the subtle difference between applying self-defense to an intentional killing and applying it to an unintentional, reckless killing. And really, I already explained the first. When it's an intentional killing, you're not saying it wasn't you. You're saying I stabbed him, I shot him, whatever, intentionally. But I did it with the legal defense of self-defense, the legal justification of self-defense. So you're conceding to the underlying conduct. You're conceding to basically the elements of the underlying charge, the murder charge, the intentional killing of another human. Now, of course, implicit in that is the intentional killing of another human other than in self-defense, right? But you're conceding the intentional killing of another human. When you are charged with reckless killing, unintentional killing, the elements there are that you created an unjustified risk of death to another person. Well, you're not conceding to that when you raise self-defense to reckless manslaughter. So it's not like an intentional killing where you're conceding the elements of murder, confessing to the elements of murder, but avoiding confession and avoiding legal liability through the legal justification of self-defense. When you're raising self-defense to the legal charge of reckless manslaughter, what you're not doing is conceding the recklessness. Indeed, what you're saying is it was not reckless because it was lawful self-defense. Remember, recklessness is the unjustified creation of risk, the knowing creation of an unjustified risk. You're saying, but it was not unjustified. It was the knowing creation of risk, but I reject the unjustified element of recklessness. I'm not confessing to the elements of reckless manslaughter and seeking to avoid liability through self-defense. I'm saying it wasn't reckless because if it was self-defense, inherently self-defense is a reasonable act. Reasonableness is one of the elements of self-defense. So it was an unintentional killing, but it was done when you were committing a lawful act in a lawful way, trying to fight for control of the knife so you don't get stabbed. And you're doing that, you're using that force to defend yourself, the elements of self-defense. So That's how self-defense as a legal justification can apply to first-degree manslaughter, reckless manslaughter in this context, even though reckless manslaughter is an unintentional killing. So I know many of you, if you're hearing this for the first time, if you're not legal professionals, it can seem like a distinction with no difference, right? What difference does it make? It ends up in an acquittal either way if it's successful. But the difference is why this trial lawyer screwed up, because he didn't understand the difference. He didn't understand a subtle distinction between raising the legal defense, the legal justification of self-defense in the context of an intentional killing like murder, and differently in the context of an unintentional killing like reckless manslaughter. So now that I've explained my view on that, let's see how the appellate court deals with all this. Analysis. So, Ms. Moreno's sole argument on appeal is that she was deprived of the constitutional right to effective assistance of counsel when her attorney failed to request self-defense instructions as to the offense of first-degree manslaughter. So what Andrea is arguing here is that no rational, effective lawyer could have made this argument, that self-defense did not apply to reckless manslaughter as a legal defense. This was not a strategic decision. And trial lawyers make strategic decisions all the time. They're often making decisions about whether or not, for example, a use of force was self-defense, that's one legal defense, or whether it was an accident. That's a different legal defense. The defense of accident is a legal defense just like any other legal defense. That would be moving the bureau across the room and it falls through the floor unpredictably. That's a genuine accident, unforeseeable outcome. But it's difficult to argue both simultaneously, right? Because one's an intentional harm to another, one's an unintentional, unforeseeable harm to another. And if you're arguing both of those, and often courts will allow you to make inconsistent legal defenses, but do you think a jury buys that? So as a practical matter, the trial lawyer has to make a strategic choice. I'm going to raise one defense or the other defense. I can't credibly raise both. So the failure to raise one or the other is not ineffective assistance of counsel. It's a strategic decision made by the lawyer. But there's a rational explanation for the choice. Here, there can be no rational explanation for the failure to recognize that self-defense was a legal justification to first-degree manslaughter. That's Andrea's argument here. That was successful with the appellate court. They get a little bit into what it means, effective assistance of counsel. Both the federal and state constitutions guarantee criminally accused persons the right to effective assistance of counsel, which, by the way, is a very low bar. I mean, you can be a pretty bad lawyer and still be constitutionally effective. Ineffective assistance of counsel claims are made all the time on appeal. They virtually never win, ever. But they did this time. Congrats to Andrea. To obtain a reversal of a conviction based on ineffective assistance, an individual must overcome the presumption that their counsel was effective. So it's presumed that your lawyer, past the bar, is an effective lawyer. This entails clearing a number of hurdles. The initial burden in establishing ineffective assistance is to show trial counsel's performance was objectively deficient. When the alleged deficiency is the failure to request a jury instruction, this requires showing that the defense was entitled to the instruction and counsel's failure to request the instruction was not based on trial strategy or tactics. If the deficient performance hurdle is cleared, so you can show there was no rational explanation for the failure to request a jury instruction, there must then be a showing of prejudice. In other words, that the error mattered. So there's really three things you need to win on any appeal. One is that whatever the claimed error is, was preserved at trial, typically preserved by objection. Second, that the appellate court agrees it was a legal error. And third, that the legal error made a difference, that the outcome, the verdict of the trial would have been different but for the error. Now, I said the first of those was that the error has to be preserved at trial by objection. One exception to that requirement is if the error is of constitutional import, and also if the error was the result of ineffective assistance of counsel. Because you can't really hold someone whose argument is, my lawyer sucked so bad it was a violation of my constitutional rights, and then say, yeah, but your bad lawyer didn't preserve that error by objection. Well, of course he didn't. He was a bad lawyer. So when it's ineffective assistance of counsel, the appellate court makes its own evaluation of that. It doesn't have to be preserved by appeal. So one of the reasons ineffective assistance of counsel is argued so frequently on appeal is that it's something you can always argue on appeal. It's always available because it doesn't need to be preserved by objection at trial. So, but still, it had to have made a difference, right? So there was real prejudice. The verdict could have been different, but for the error. The defense need not show a different outcome is more likely than not. So it's not a probability question. Instead, the requirement is that the defense show counsel's errors undermine confidence in the outcome. So that kind of sets the framework for the rest of this discussion. One, did defense counsel perform deficiently by failing to request self-defense instructions as to first-degree manslaughter? Can that be explained away as a strategic decision, a trial tactic? To assess whether Ms. Moreno's attorney performed deficiently in failing to request self-defense instructions as to first-degree manslaughter, we must first examine whether she was entitled to the instruction. This requires us to examine the applicable law and how that law applies to her case. To be entitled to a particular instruction, the defense must show that a jury instruction accurately states the law and that it is justified by evidence in the case. And usually that's basically a more than zero evidence standard. So if there's a scintilla of evidence that could support a jury instruction, then it's a fact question for the jury to consider they should be given the jury instruction. We first address whether it was legally accurate for trial counsel to assert that self-defense instructions are inapplicable to the offense of first-degree reckless manslaughter. The legislature has identified 4 types of homicide: murder, homicide by abuse. I'd actually have to look that up. I'm not sure what they mean by that. Manslaughter, excusable homicide, and justifiable homicide. Only the first 3 types are crimes, as we talked about, right? Neither excusable homicide nor justifiable homicide are crimes. An accidental or intentional killing in the course of self-defense falls under the 4th or 5th type, excusable homicide or justifiable homicide. Because neither excusable nor justifiable homicide is a criminal act, they are both available defenses to a charge of illegal homicide, including a charge of manslaughter. Thus, contrary to what Ms. Moreno's attorney asserted during the trial, the defenses falling under the rubric of self-defense were legally available to her as to first-degree manslaughter. Given the defenses of excusable and justifiable homicide are legally available to a charge of first-degree manslaughter, she would have been entitled to the instruction so long as the evidence at trial was sufficient to raise a possible claim to the 2 defenses. As the trial court determined, there was plausible evidence of both excusable homicide and justifiable homicide sufficient to allow for instructions to the jury. As relevant to her case, excusable homicide happens when in the course of defending oneself, a defendant causes the victim's death by accident or misfortune. Another way of putting that is doing a lawful act in a lawful way. And by the way, folks, another example of this might be if you're attacked by somebody with a machete and you draw your pistol and you shoot at them and the bullet overpenetrates. So you get a good hit, the bullet overpenetrates, goes on and strikes a bystander, kills the bystander. Well, you killed that person too. Is that an unlawful killing? Is it a social good? No. Were they attacking you? No. So it's not a justifiable killing in self-defense, but is it an excusable killing in self-defense? Arguably so, because your firing of the shot at your attacker was in good faith. It had good intent, and that intent transfers over to the bystander. So even though the bystander getting shot and killed by your bullet is not a good thing, not what you intended, it's still not a crime because you were committing a lawful act in a lawful way. It's simple misfortune. And as relevant to Ms. Moreno's case, when a person's intentional act of self-defense kills a person, the killing is justified if there was reasonable ground to believe the person slain posed an imminent danger to the defendant or another person. That's just straight up traditional self-defense, intentional self-defense. There were facts at trial to support plausible claims of excusable and justifiable homicide. She testified that just prior to the stabbing, the boyfriend obtained possession of the knife. At that point, she stated she worried he was going to hurt either himself or her. Given the danger allegedly posed by the boyfriend, she would have been legally entitled to disarm him. If during her purported attempt to engage in this lawful conduct, a lawful act in a lawful way, she accidentally stabbed him, then her unintentional act of killing would have met the criteria for excusable homicide. Alternatively, if during the purported struggle over the knife, she found herself in imminent peril, she may also have been justified in intentionally stabbing the boyfriend in order to save herself, which would be justifiable homicide, straight up self-defense. We note her testimony that she feared the boyfriend was bolstered by her testimony regarding their turbulent history, her expert's opinion regarding the relationship between her and the boyfriend, as well as the evidence of fresh injuries that were visible on her face. There's a footnote here regarding her expert's opinion regarding the relationship between her and him. This was battered spouse syndrome testimony. So the footnote reads, during her case in chief, this would be the defense half of the trial, she presented testimony from Dr. April Gerlach, who opined that she suffered from battered person syndrome and post-traumatic stress disorder. So what battered person syndrome does is it typically applies in cases where a woman's killed a man, say, often under circumstances in which self-defense just clearly doesn't apply because the man was not in the moment presenting any kind of imminent threat. He's asleep or passed out in bed, and she pours gasoline over him and sets him on fire and kills him. That's not self-defense, right? It looks a lot like murder. But because society has said, well, if that burning bed was the act of a woman who had a long-term history of abuse at the hands of the person killed, we will treat it kind of like a heat of passion killing, even though there was no actual heat of passion in the moment. So it doesn't qualify as a voluntary manslaughter either. But we'll treat it in a similar manner to heat of passion manslaughter. We'll say the pattern of abuse created a mental state in that woman's mind that should mitigate what would have been a murder conviction to a manslaughter conviction. So that's what the battered spouse syndrome testimony is all about. Let's see. The evidence supported instructions on both excusable and justifiable homicide, despite the fact that these two defenses contemplate inconsistent mental states. Justifiable homicide requires an intentional fatal blow. It is not available when a fatal blow is accidental. This is the traditional application of the justification of self-defense. In contrast, excusable homicide requires accidental conduct, unintentional conduct. Had she been able to clearly and consistently describe her mental state at the time of the stabbing, she may have been entitled to an instruction only on the type of self-defense that coincided with her testimony. Another reason not to talk to the police, to investigators, folks, without your lawyer present. Your lawyer, a good lawyer, maybe not this lawyer, your lawyer would know this. And your lawyer would not be allowing you to say things that undermined your legal defenses at trial. In fact, your lawyer would make sure that you said the things that buttressed your legal defenses at trial in order to make you look as hard to convict as possible. So maybe you don't have to go to trial in the first place. But she didn't know what to say. This happens all the time, folks. I see this in most of the cases I consult on. Had that defendant had the benefit of my counsel, competent legal counsel on use of force law, they would have known what to say. And it's not that, I don't mean to suggest that they would have been making things up, but the right words were there to be honestly said and be decisive on the question of self-defense. They were there. The defender just didn't know they were there, and so didn't know to say them. And when you don't say them when you're speaking voluntarily, then when you say them later, it looks like a pure fabrication. Let's see. When a defendant's memory as to their mental state at the time of the fatal blow is unclear or imprecise, instructions on both defenses are appropriate so long as circumstantial evidence supports either mental state. Again, as long as there's a scintilla of evidence to support a jury instruction, the jury instruction should be given. Because the record supports plausible defense theories of excusable and justifiable homicide, it would have been an abuse of discretion for the trial court to refuse to extend those instructions to manslaughter in the first degree had they been requested. Thus, had defense counsel requested the instructions, the court would have been bound to give them. The fact that she was entitled to instructions on excusable and justifiable homicide does not necessarily mean her attorney performed deficiently in failing to ask for them. It doesn't necessarily mean that, but it does mean it in this case, as the court will continue. As previously noted, an attorney's performance is not ineffective if is doing a lot of heavy lifting here, folks, if it can be explained by legitimate trial strategy or tactics. But here, no conceivable strategy explains counsel's error. Her trial attorney repeatedly explained they did not seek excusable and justifiable homicide instructions as to first degree manslaughter because of the mistaken belief that the defense was not available. An attorney does not act strategically when they make a mistake of law. Would not have happened if I was on that legal defense, folks. Not as legal counsel, of course, not as lead counsel, rather, but as a consultant to lead counsel to make sure these errors were not made. Despite defense counsel's legal error, the state argues we should decline to find deficient performance because instruction on self-defense would have contradicted her theory that he was killed accidentally. We disagree. For one thing, the defense theory of accidental killing is completely consistent with the defense of excusable homicide. In addition, because her testimony regarding her mental state was imprecise, justifiable homicide was also available. The jury is allowed to make their own findings of fact. Defense counsel could have comfortably argued their theory of the case by asserting that at the moment of the killing, she was engaged in lawful defensive conduct and that the stabbing occurred either because she intentionally sought to repel an imminent attack or because she was reasonably acting to disarm him and accidentally stabbed him in the process. A lawful act in a lawful manner. Misfortune, not recklessness. Defense counsel's failure to request instructions on justifiable and excusable homicide as to all of the homicide offenses at issue in this case was constitutionally deficient. Part 2 of the analysis by the appellate court. Did defense counsel's deficient performance result in prejudice? So again, 3 things to get a reversal, right? The error was preserved or didn't need to be preserved, as in this case. The claimed error is agreed by the appellate court to have been an actual error. They just decided that now. It was. And 3, it made a difference. It mattered. The verdict could have been different. As previously explained, a claim of constitutionally deficient performance by trial counsel will result in reversal of conviction only if the defense can show prejudice. Proving prejudice involves more than showing a conceivable effect on the outcome, but at the same time, the defense need not show counsel's error was more likely to sway the outcome. Indeed, the required showing is a reasonable probability of a different result, sufficient to undermine confidence in the outcome. Here, the record as a whole shows prejudice. The court's instruction stated the defenses of excusable and justifiable homicide applied to first and second degree murder, as well as second degree manslaughter. So each of those charges had self-defense stapled to them as a justification. But first degree manslaughter was treated differently. It did not have self-defense stapled as a defense. The instructions did not identify excusable or justifiable homicide as defenses to first degree manslaughter. This different treatment created a serious risk the jury would interpret the first degree manslaughter as an offense that was legally different from the others. As worded, the jury instructions improperly suggested she could be convicted of first degree manslaughter even if her conduct would otherwise be understood as either excusable or justifiable. And remember, folks, the jury did acquit her of the other charges where the self-defense instruction was stapled. That's the appellate court's concern here. Had those same self-defense instructions been stapled to first-degree manslaughter, would she have been acquitted of that too? The state argues that because the jury found she behaved recklessly, as required for first-degree manslaughter, it could not have found that she engaged in excusable homicide or justifiable homicide. So this is circular reasoning by the state. The state is saying, Well, to find her guilty of first-degree manslaughter, one of the elements is recklessness. If it was recklessness, it was not lawful self-defense. Here's the problem. The jury was not told to consider lawful self-defense in the context of the first-degree manslaughter charge. If they had been, they might have concluded, oh, you know what? It wasn't reckless because it was, in fact, lawful self-defense. So you can't say that the jury discounted self-defense to wipe out the recklessness element of manslaughter when they didn't have self-defense to consider with respect to the recklessness element of manslaughter. The court continues here. It is true that a reckless killing cannot constitute either an excusable homicide or a justifiable homicide. This is because excusable homicide requires the absence of a culpable mental state, and recklessness is a culpable mental state. You're knowingly creating an unjustified risk of death. And justifiable homicide requires intentional conduct, not a reckless disregard for harm to others. Despite the difference between reckless conduct and the other mental states contemplated by excusable and justifiable homicide, the record in this case presented a real possibility for confusion. The prosecutor argued to the jury that her reckless conduct began by following the boyfriend out to the vehicle. Given the implication from the court's instructions that excusable and justifiable homicide did not apply to the offense of first-degree reckless manslaughter, which requires proof of recklessness, there is a risk the jury believed that once it found she had engaged in reckless conduct by following him out of the house, she was no longer entitled to act in self-defense, even if a renewed need to defend herself subsequently arose. So just because you did one reckless act earlier in the process doesn't mean that's the recklessness that makes you criminally liable for the death at the end. It needs to be proximate to the death. Quoting now, self-defense instructions are subject to heightened appellate scrutiny. The instructions must more than adequately convey the law. The instructions read as a whole must make the relevant legal standard manifestly apparent to the average juror. This, by the way, was the fatal error never resolved in the Ahmaud Arbery trial with the McMichaels and Roddy Bryan, all three of whom were convicted of murder, life sentences at the state level, and I believe either 20 years or life at the federal level. Because the jury instructions were not manifestly apparent. The whole key to the Ahmaud Arbery case was the citizen's arrest. Because if their pursuit of Arbery, if they were privileged to make a citizen's arrest of Arbery, then everything that followed was lawful. The pursuit was lawful. The attempt to stop was lawful. And then when Arbery charged them and fought them for control of their firearms, defending themselves against that attack was lawful. But if the citizen's arrest was not lawful, then everything that followed was not lawful. The pursuit was not lawful. The stop was not lawful. And the resulting fight was not lawful. So the whole key to the case was that citizen's arrest statute. And the citizen's arrest statute was ambiguous. It had been written in like 1865. It used words, phrases that later, 100 years later, Supreme Court decisions became legal terms of art, but were not necessarily legal terms of art when the citizen's arrest statute was drafted by the legislature. And there was two possible readings of that citizen's arrest statute. One of them would have made the citizen's arrest lawful. I think that was the correct reading. But the other reading would have made it unlawful. Well, when a statute is ambiguous, it's unclear, it's not manifestly apparent to the jurors, it's the job of the judge to clarify the statute, to make a decision of law. This is how the statute's supposed to be applied, in the manner of A, not the manner of B. Now, if the judge makes that kind of decision of law, tells the jury what the law is, as opposed to letting the jury decide what the law is, which is not the jury's job. The jury's job is to decide what the facts are, not what the law is. Now, the judge makes a decision of law and says, you need to apply it in manner A, not manner B. Is that a legal decision made by a judge that could be appealed? Sure, of course. That's what the appellate courts do. They review decisions of law at the trial level. But that is the judge's job. And frankly, if the trial judge had made the call either way, he would have been doing his job. I would have agreed with one way, not the other way, but he would have been doing his job. But here's another complicating factor. When a criminal statute is ambiguous and it's subject to two interpretations, one of them favorable to the defense and the other not favorable to the defense, there's a legal doctrine called the doctrine of lenity that says the defendant gets the benefit of the favorable interpretation. Because the defendant didn't write the statute, the legislature wrote the statute, and if they left it ambiguous, that shouldn't be held against the defendant. And under the doctrine of lenity, the trial judge in the Ahmaud Arbery trial would have been obliged to interpret the citizen's arrest statute in the light most favorable to the defense, which would have made the citizen's arrest lawful and everything that followed lawful. And I think the judge knew that. And the judge knew he would have been characterized after an acquittal of those three men as having gotten them off on a technicality, is how the media would have reported it. And surely those men were racist, so the judge must be racist too. And so the judge didn't want to do his job, didn't want to take that heat, just pass that legal hot potato, that question of law to the jury, and we got the convictions. And those convictions are wrongful on that legal merit alone, regardless of what else you may think about the case. Okay, back to this particular case. So the jury instructions are supposed to be manifestly apparent to the average juror. Had the jury been properly instructed, it may well have been satisfied that regardless of her initial reckless conduct in following the boyfriend out of the house, she was nonetheless legally entitled to defend herself when, according to her testimony, the boyfriend wrested the knife away from her and appeared ready to harm himself or her. Given this possibility, it was crucial that her jury receive accurate instructions regarding the applicability of excusable and justifiable homicide. Counsel's deficient failure to request instructions on excusable and justifiable homicide as to the first-degree manslaughter of which she was convicted prejudiced the outcome in this case and deprived her of a fair trial. Her conviction for first-degree manslaughter must be reversed. The judgment of conviction is reversed. The matter is remanded for further proceeding, which may be a retrial or maybe not. So lots wrong with all of this by everyone involved. So I think the prosecutor made bad legal arguments here. I think the defense obviously made bad legal arguments. That's why they were found to be ineffective, constitutionally ineffective in representing their client. Of course, the client made misjudgments too, but let's just look at the legal professionals. And the trial judge should have given the instruction, even if it was not requested, because it was actually supported by evidence in the case. So folks, when you go to trial, heaven forbid, you may be thinking that those people, your defense lawyer, the prosecutor, and the trial judge, all being legal professionals, actually know the law. And generally speaking, they do. But sometimes they don't. And sometimes where they don't, it's critical to your verdict. And if you're claiming self-defense at trial and they screw up the self-defense law, what do you think happens to you? Nothing good, folks. You get wrongfully convicted because they had an imperfect understanding of self-defense law. And you know who has a perfect understanding of self-defense law. Well, as perfect as human frailty can allow for. But folks, I renewed my bar license. I got it in the mail today. Admitted date, August 13th, 1991. Now it's 2023. 32nd year doing use of force law. The only law I practice. I think I'm pretty good at this. I think errors like this do not happen. They do not happen on cases on which I consult. And folks, the only people to whom we provide legal consultation, effective as last year, is to our Law of Self-Defense Platinum Protection members. Now, this is a level of Law of Self-Defense membership that's above the standard membership. The standard membership is just, you can try it out for 99 cents. It's only 30 cents a day if you're a standard member, less than $10 a month. You can become a standard member right now. Do the trial. 2 weeks, 99 cents. You get unlimited access to all our members-only content. Ask all the free questions you want. Lawofselfdefense.com/trial. But being a standard member does not get you our legal consult. To get our legal consult, you have to be a platinum member of Law Self-Defense. And if you are a platinum member, you get the legal consult for free. Now, when we were taking external consults from non-platinum members, our initial base retainer was $10,000. And then it went up from there. You're a platinum member, there is no retainer. If you're a platinum member at the time you're involved in the use of force event, you're being criminally prosecuted, you need our legal consult, you get it for free. It's just part of your platinum membership. Also, another benefit of your platinum membership is you get access to a Q&A form that comes directly to me. Ask any question you want in that Q&A form. You get a reply directly from me. Another benefit of being a platinum member. I would encourage you, if you don't want to be in jeopardy of having this kind of legal defense. And by the way, this error got fixed, right, by the appellate courts. 4 years, 5 years in prison, waiting for this error to get fixed because her trial lawyer was bad, plus whatever she paid for the legal defense. You don't get that money back. If you want to make sure you have the most robust self-defense legal defense you can have at trial without having to be concerned of being at risk of these kinds of legal errors, the best way to do that, in my humble opinion, is to have me be part of your legal team, backing up your lead counsel, providing a legal consult to your case. And the only way to get that is to be a platinum member at lawselfdefense.com/platinum. Okay, time to look at questions. But before I do, again, this is so rare that a client on appeal, an appellant, gets meaningful relief from an appellate court, much less reversal of a conviction, much less on ineffective assistance of counsel grounds, that I just have to give kudos once again to Andrea Burkhart. By the way, she is on Twitter. This is her Twitter handle, @ABurkhart She's a very good lawyer. You all know, you've heard me criticize lawyers before when I think they don't engage in good reasoning. That's how I got my car. Andrea Burkhart's not one of those lawyers. She is a smart lawyer. So well worth the follow. She's on YouTube as well. I would recommend you follow, subscribe, all that stuff there as well. Very, very sound lawyer, as this reversal for her client shows. And by the way, this is, where is she? Where's her name? Oh, it's in here somewhere. I can't find it now. In any case, well worth the follow. So, lawselfdefense.com/platinum, and you get my legal consult for free, folks. All right. So let's take a look at the questions. First, of course, we turn to the member questions. Let's see. Let's see. Yes, I'm back in the office. I'm back from my trip, folks. Very, very happy to be back. Had a great time. Stephen, Law Self-Defense member Stephen asks, why do law enforcement agencies, DAs, and public defenders not offer the legal aspects of self-defense law? I've asked my local agencies and none are interested. What do you think, and how can one start such an event without participation of law enforcement, DAs, and public defenders? I'm not sure what you mean by why do they not offer the legal aspects of self-defense law. Do you mean why don't they teach it? Mostly because they don't know it, is the truth. Law Self-Defense member D says, when taking victim statements, unless the victim specifically mentioned self-defense, we couldn't bring it up. We were cautioned to gather facts and not to offer legal advice. When taking victim statements, I presume this is a law enforcement function. Yeah, law enforcement, I mean, they don't technically work for prosecutors, I guess, unless they're an investigator in the prosecutor's office. But, their report goes to the prosecutors. It doesn't go first to defense counsel. And so prosecutors will send back to cops, hey, we prefer it if you do it this way and not that way. Don't volunteer self-defense as a legal defense. when you're taking a victim statement. If they offer it themselves spontaneously, fine, write that down. But don't suggest it. Law self-defense member JS says, if there is a retrial in this case, would it be on the murder charge or is it limited to the manslaughter charge only? The manslaughter charge only. Any charges she was acquitted on at this initial trial are double jeopardy applies. She can't be subject to those criminal charges again. Law self-defense member Jeffrey says, I'm a new member. Do the live broadcasts typically start at the same time? And I'm embarrassed to say the answer is no, but I'm working on it. I'm going to strive to get to a single time. I'm going to try to make it something like today's show, like 11 a.m. Eastern time. But that should be thought of more as a policy rather than a full promise, because I have client responsibilities, I have travel obligations, I have other things that can readily interfere with that schedule. But moving forward, I'm going to strive to do the shows relatively early in the morning, my time, 9 a.m. Mountain Time, where I am in Colorado, so everyone can have an expectation of when the shows go live. I will say, of course, for Law Self-Defense members, you also get the playback version of every show in members-only shows and open access shows in the Law Self-Defense members blog as well as on the member podcast, the Law Self-Defense members only podcast. Let's see. Yeah, the best way to know when a show is going to go live is email, folks. Make sure you're on our email list. Make sure you whitelist us or whatever you need to do. There's email getting through can be difficult. I'm not a technology expert on that stuff. I'm not sure how that works, but we always send an email before we go live. Let's see. Jack, Law Self-Defense member Jack asked, was it reasonable for her to follow him? Did he regain innocence when he retreated? Sure, you can make that argument. When he left the house and she pursued him, maybe whatever he'd done inside the house, he regained innocence by withdrawing and communicating. And maybe she became the initial aggressor when she comes out of the house with the knife. Except by her accounting, that second fight stopped too. And then a third fight began inside the vehicle. So then you'd have to look at that third fight in the context of what was happening right then. Law Self-Defense member Jeffrey asks, I'm planning on taking the instructor course next month while on vacation. Do you deal with the question of raising self-defense in manslaughter cases? I honestly don't remember, Stephen. We cover like 15 hours of content in the instructor program. By the way, if anyone's interested in that, this is a course of instruction for self-defense instructors that we created to replicate what it would look like if a law school had and I just put it up there on the screen at the bottom, if a law school had a semester-long course on self-defense law, a semester-long seminar on self-defense law, that's what our instructor program is designed to replicate. So it's a law school level education in self-defense law. It's some 15 hours of content. There's reading assignments. There's what you would expect of a law school level seminar. Whether in that 15 hours I touch upon that specific question, I can't remember. Honestly, I could do 100 hours on self-defense law, and that just would get to be too unwieldy. The best way to stay fully involved on self-defense law, in addition to taking our full-day advanced class or the instructor program, which basically includes the advanced class content, is what you're doing now. Just watch our weekly, almost daily content and ultimately we cover, every facet of self-defense law using these kinds of real-world cases to illustrate them. Law Self-Defense member Kyle says, wasn't there an appeal on ineffective assistance that failed despite the attorney sleeping through the trial? Well, not through most of the trial, but there was a time when the lawyer nodded off during the trial. But remember, it's not enough that the lawyer made a mistake. The mistake also would have had to have made a difference. So if the appellate court says, well, yeah, he slept for 10 minutes during the trial, but had he not slept through it, it wouldn't have mattered. It wouldn't have changed the verdict in the case. Well, then it's not ineffective assistance of counsel for purposes of reversing a conviction. Law self-defense member Oscar asked, does lenity only apply to criminal charges? I don't know. I don't do enough civil law to know if it would. Normally in civil law, often it's not a case of some statutory violation. So there's no statutory interpretation happening. So the doctrine of lenity wouldn't apply. Normally it's a case of, you caused some injury to somebody else, and they're claiming you did that in violation of a legal duty, the general legal duty not to cause avoidable injury to others. And that's why you're getting sued in civil court. Let's see. Law self-defense member Clay says, have you seen the video of the guys pranking that they're pouring gas on people's vehicles and saying they're going to burn it? They came very close to getting shot. If I send it to you, would you look and give your opinion? Yeah, I think I did save that. I saw that video myself. I think I saved a copy of it. I do plan to cover it. And yeah, that's an excellent way to get yourself shot. Especially, by the way, if there are, just imagine there's people in the car, like children strapped in a car seat in the back seat. And it would take some time to extract them from a vehicle that had been set ablaze. If that's my car, my kid's in it, and you present yourself credibly as if you're pouring gasoline on my car and are about to light it on fire, that's an excellent way to get shot. Law self-defense member Dave says, your local law enforcement agencies don't offer law self-defense education because it's not required to perform their duties. That's fair. But they do all kinds of stuff that's not required to perform their duties. They do citizens academies. They do public outreach on various things. Sometimes they offer like self-defense classes for women when there's been, a flurry of rapes in the neighborhood. So not everything they do is only what's required for their duty. Okay, that's all the law self-defense questions. Let me see if there are any super chats that I need to address. Go over here. Super chats need to be $5, folks. $5 minimum. One thing I should mention, folks. So it doesn't look like there's questions from today. You may have noticed, if you watch our content on YouTube, that we started posting on YouTube what are called shorts. These are like 5 or 8 or 10-minute videos. These are not standalone videos. These are small segments that have been cut out of these longer form shows. Like today's show is almost 2 hours. So we're working with a partner that looks at our content, finds the kind of cherry picks some particularly good parts, and then reproduces them as shorts that they put on YouTube. So that's what you're saying. If you watch the long form shows, you've seen the shorts. So it's not new content in that sense. It's content that we've already created. It's just being presented in a different way. Because some people only like to consume, 2 hours is a big time commitment to listen to a show like today's. Some people like to prefer the shorts. We've been asked by members if those shorts are also going to be presented on the Law Self-Defense member blog. It hadn't occurred to me to do that, frankly, because this is brand new. We've only been doing this for the last week or so, and much of that I was traveling. I'm only in the office for the first day today, back from my trip. But I will talk to our partners and see whether or not it's practical for us. I think it should be practical for us to put the shorts on the member dashboard, the member blog, so you can enjoy it there as well. So we will definitely look into that. But if you see the shorts on YouTube, that's not content that's not already being provided to members. It's just the members are getting it currently in the long form content, long form manner. So, and our goal, of course, is always to help grow the law self-defense community. The larger we can make the community, the less expensive we can make every facet of it on an individual basis for everyone in the community. Our costs are relatively fixed. So if we can double the size of the community, we can, in theory, greatly reduce the per person cost of participating. So that's our goal, to make it all as easily accessible, as inexpensive as possible for everyone. And let me take a look at Rumble rants, if there are any. Oh no, Rumble is clear. All right, folks. So with that out of the way, then I will wrap up. We're almost at the 2 hour mark. I will just remind all of you, as always, that if you carry a gun, if you have a gun so that you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law Self-Defense. Stay safe.